Hello, I am back with more true crime. Hello, hello. I'm being nosy. I'm looking in the freaking chat. Hi, happy Friday. We're back. I know I was supposed to go live last night, but honestly, I'm not even going to bullshit you. I was tired. Like, I don't know if it's the weather. I've been doing a lot in my personal life as well, but regardless, I couldn't even do it last night. I don't know what it was. But yeah, I do thank you, Manji. I am feeling restful, yes. But I did manage to get the second channel up. So there's a lot going on. There's a lot going on. Melly, you were my top watch channel for 2025. I believe that. I do believe I was yours, Ausane, but when I went back through my recap that YouTube gave me, I found that it was not really accurate. So I don't know, I'm throwing shade, but not at you. Anyways, nonetheless, I appreciate that. I'll say you're not the first person that tells me that. So I do appreciate everyone who has supported my channel. We have been live for a little bit over a year. And the second channel just launched. So Melly, why is there a second channel? Because I love true crime so much that I want it to be its own thing. And so I have a true crime channel, which is this here. Hello, hi. This is True Crime with Melly. Melly, whatever you want to do. I think most people know, well, who I hang out with in the chats and stuff, who I am, and that I have a channel. But the second channel is like a far more personal. So if you're not into that, you don't want to see craziness, you don't want to hear drama, you don't want to hear me talking shit, you don't want to hear me partying, like any of that, then don't go and subscribe. But do subscribe if you're into that kind of thing. We'll be reviewing other channels over there. We'll be Party Time, Melly After Darks will all be moving over there. I am still going to be doing something different for the members here on this channel than the members over there. So there's a lot going on. The giveaways, all of that will be done for the most part on the second channel. So I have been working pretty hard on it. I do have an idea, a vision of what I would like it to look. So if you guys could please go up and subscribe. I have the link pinned. It's Brains and Bad Decisions with Melly. And I launched it last night. We're going to do our first After Dark over there tonight. And I'm really excited about it. But back to true crime, I will say hello to everyone in the chat. Shout out to all the members, the viewers, the subscribers, the haters, the lovers, all of you. Hello, I am Melly. If you have a problem with that, please see me about it. Let's get started. We are going deep into Courtney Clenney again. I know. It's like the never-ending case. I feel like Courtney Clenney's up there with like Karen Reed. It's like, when will it be over? When will we be done hearing the name? Courtney Clenney has been incarcerated since she stabbed her boyfriend to death, allegedly, in self-defense. We have covered Courtney Clenney here, so I'm not going to give you a big spiel about it. There is a playlist. You know who she is. She was the OnlyFans model, like I said, who stabbed her boyfriend to death. And she has been fighting to get a bond. She thinks that her charges should be less, because she is, what do you call, a battered woman. We heard that term in the Ashley Benefield case. You might know her as the Swan, was it Black Swan dancer? I don't remember. And then Sarah Boone also. And so Courtney Clenney, and this new motion that was just dropped on the 3rd, is saying, hey, because there has been a lot of shadiness going on, and I'm not going to get into detail. Like I said, go watch the previous lives. I have been keeping up on the Courtney Clenney case. I feel like I'm one of the few channels who has, because it's been an ongoing thing. So the district attorney on that case got removed. That was the whole thing. Her parents got arrested for some cyber shit. That was the whole thing. Charges were dropped. Courtney's been fighting for bond, and she hasn't got it. And I don't know, she might get it this time. She might actually get it. The prosecutors and DA's office has made many mistakes in the Courtney Clenney case. And so now her lawyers are back saying, hey, with these mistakes that you've made, and now that they have a new health professional coming in and stepping in and saying that she was battered, basically she's fighting to get out on bond again. Her trial was supposed to start on December the 1st. That did not happen. Now I'm getting word that if it does, it would probably be mid-2026, which is absolutely crazy. So we're going to read through the new motion. The new motion does have attached new exhibits that, older exhibits that I'm not going to read through. If there's a document that I've already read on here as of recent, I'm not going to read it in this one. So I will lead you to the Courtney Clenney playlist, because over there, we've been getting into all the documents. So we are going to get started with this document. I see Pretty Fly. Laura, my mod, is asking, are you not covering Walsh today? I have to be honest with you guys about trials. It's totally something else. And I don't know if I love it. Like, I don't know if I love covering those trials. I feel like I'm too hyper for that. Like, I'm too sitting for long periods of time doesn't bug me, but I have to be actively doing something, actively shaking my ass, actively working out, actively, like, I have to be moving. And so those are really hard for me. So I needed to take a break today. Am I going to continue it? I do want to. I don't know that I'll continue it during the day. I might do like the play by play later. And so many channels are covering it. And I just was like getting tired of going into my YouTube and being like, okay, everybody and their mom is covering this. So I'm like, there's so much other stuff I need to get going on. And we have Kenzie calls and we have a bunch of cases I just FOIA'd, and I haven't even gone through 7,000 pages of documents because, we're too busy. But nonetheless, never too busy to shake that ass and have some fun over on the second channel. So please definitely subscribe there. And let's get started with this motion. I did see Laura, Asain, Tasha, Cree. Okay. I see a lot of you popping in here. Thank you for being here. Sunshine, Patty and the Natty, Cryptician, what up? I saw Debbie. Hello. Heavenly, La Pedora. Hello. I saw Nikki, Ohio. Hello, babes. Buzzball, Melly. But I know I have to get through 2 lives. We have to get through this one and then a Kenzie live. And then I already got the buzzballs in the refrigerador waiting to be drank. They're just like, hello, are you going to open me up today? Are you going to open me up? Swan dance. I forget her name. But anyways, Ashley Benfield. Cat Randa, I love you. Your ass is great. Don't worry. Anyways, so I do think Courtney Clenney is going to get on bond. And if she does, please, Kat Randall, I'll say nobody date her because I don't want anyone to get stabbed. Kat Randall, I love you. I appreciate you. Okay, let's get started. So here's the document. Like I said, it's long, but a lot of it is old exhibits that we're not going to read. Let me make sure I'm not doxing myself on here because I've been doing that lately. Not that it matters because you guys are about to find out all my secrets on the second channel. Everything. You're going to see me in my birthday. Just kidding. You're not. But pretty much that's how deep we're getting on the second channel. Wait, pause. That also sounds dirty. That's how intense and detailed we will get over there. Okay, so this was filed on December the 3rd. Courtney Clenney, her Judge Andrea Wolfson comes now defendant Courtney Clenney. Okay, we're not going to read through that. It says, Honorable Court to reconsider its prior rulings denying bond. And this is why. So I will read through a lot of the a lot of the factual stuff just for those people that aren't new to the case. So in this case, the state has charged the defendant, Courtney Clenney, in the death of her boyfriend, Christian Obumseli. The events leading to Mr. Obumseli's death occurred on April 3rd, 2022, at the apartment of the defendant. Mr. Obumseli was not on the lease. He was not an authorized guest that stayed with her. All rent for was paid by defendant Courtney Clenney. And like I said, there is a playlist with the body cam and stuff, which we will probably be reviewing at some point because I don't know. This case is always the body cam is like super extra. So I feel like I always want to watch it over again. So let's continue. I already said that. He was not on the lease, so she was paying for the rent. She was an OnlyFans model. Prior to April 3rd, 2022, Miss Courtney Clenney attempted to remove the decedent from the apartment. Miss Deborah Clenney, which is Courtney's mom, flew to Miami to help her daughter remove the decedent from the premises. The decedent attempted to remain on the premises by secreting himself in the common areas of the building and other areas of the complex, as he had no means of income to obtain alternate accommodations. After these events, the decedent was able to manipulate Miss Clenney to successfully access her apartment. I have a problem with this. Manipulate Miss Clenney. Many of us think Courtney Clenney is guilty. Many of you might think she is actually a victim of self-defense. I think Courtney Clenney has mental health issues, but I do think she's guilty. Do I think those should play a factor in the length of time she gets in jail or prison? Maybe. And do I think she should be out on bond? Maybe. No, but I think, like, when it comes to the in my moral opinion, compass says no, she shouldn't be out on bond, but the legality of it all, I feel like she could possibly get it. Um, so it says after these events, the decedent was able to manipulate Miss Clenney to successfully access her apartment. This was after he sent her close to 200 unanswered text messages to Miss Clenney during this time period that he was no longer welcome in her apartment. Shortly after April 3rd, 2022, undersigned counsel was retained by both Miss Clenney and her family to represent all parties. During the months prior to her arrest, undersigned counsel was in constant contact with both the Miami SAO and the City of Miami Police Department. Undersigned communicated with both agencies to arrange Miss Clenney's self-surrender should a charging decision be made. So they're basically saying like what because Courtney Clenney, if you don't know, she got arrested while she was going to allegedly do rehab in Hawaii. I know. And it's like, okay, now you thought of going to rehab after you're gonna go to prison. But that could have been a thought in her and her parents' mind a lot sooner than that, since she did have the means to get to a freaking rehab place. But nonetheless, I'm not here to judge just a little bit. But you know, the basically that they're saying that they never gave her the opportunity to turn herself in. Whatever. And so they arrested her, they extradited her. After the events of April 3rd, 2022, Ms. Clenney sought treatment for her substance abuse issues and her post-traumatic stress disorder. This ultimately culminated with her paying for and traveling to Hawaii to attend an inpatient program that specialized in treating both issues. Again, at all times, undersigned counsel was in contact with both the Miami SAO and the City of Miami Police Department investigators. On August 10th of 2022, the defendant Courtney Clenney was formally arrested and charged with second-degree homicide via an arrest warrant and the use of SWAT teams located in Hilo, Hawaii, where she was attending the inpatient treatment program. I did want to mention another reason why she wants to get why that what else they're going to include in this document is the defense is saying that Courtney Clenney is now broke. So therefore, she cannot be a danger to the community because she does not have the possibility to flee because she is broke. Now, do we believe that Courtney Clenney is broke? I don't know. I mean, it's been a while that she's been fighting this case. So attorney fees are expensive. But at the same time, her OnlyFans, I believe, is still up. So she has to be making some money. Right? I don't know. Despite previous communications, neither the Miami SAO nor the City of Miami Police Department contacted counsel to arrange for her self-surrender. So that's what I was just mentioning, that she wasn't able to self-surrender, which I don't know what the law is about that. I do know in some cases, like, obviously, you have to turn yourself in, but I don't know what the deal is behind why they didn't do that. So that's why it's being brought up here. Following an Arthur hearing and pretrial detention hearing held on November 15th and 17th of 2022, the court ordered Ms. Clenney to be held without bond. On or about August 3rd, 2024, defendant filed her motion to dissolve the pretrial detention order issued on December 8th, 2022, citing the first breach of attorney-client/work product privilege on the part of the government that caused significant delays in this matter. Additionally, defense argued that witnesses and expert witnesses, previously unknown, changed the calculus of the Arthur and detention analysis. On or about October 7th of 2024, Ms. Clenney filed her notice of intent to rely on battered spouse syndrome defense. On or about October 18th, 2024, a hearing on the defendant's motion to dissolve was held. That motion was denied on November 15th, 2024. Ms. Clenney has remained incarcerated since her arrest August 10th of 2022. Let me know what you guys think about this case. Her criminal history and flight to Hawaii would prevent judge from giving her bond. Plus, it's unlikely current judge will move different on the issues from the previous judge. Okay, Cryptician. She's teased us. Nah, I haven't. About what? She gave her dad all of the money. I know. That's why I think that's still going on. She's been in 3 plus years. Why do you always think should they let her out? Um, I don't know. I feel like if they've made that many mistakes, maybe it warrants for her to be let out. I personally, moralistically, don't think she should be let out. I think that, yeah, she has mental health issues and substance abuse issues, but Courtney has been doing this for a very long time. So, um, but Cryptician is right. Maybe the judge won't look at it any differently. We never know. Factual and procedure delays caused by government misconduct. On November 3rd, 2023, the City of Miami Police Department obtained and executed a warrant on the iClouds of Miss Clenney's parents, Mr. Kim and Miss Deborah Clenney. This warrant, essentially identical to the one issued in March of 2023 that had expired, sought the entire iCloud accounts of the parents from November 2020 to March of 2023. The warrant application, excessive in both scope and time, saw access to the entire iCloud accounts of the parents from November 2020 to present, extending to March of 2023. Despite the application's description of specific information sought with a limited time frame, law enforcement requested access to the entirety of the iCloud accounts. This included data from the 7 months prior to April 3rd of 2022 incident and data from 7 months after Courtney Clenney's incarceration when she didn't have access to a mobile phone to communicate with her parents or her counsel. As a consequence of the information obtained from this overly broad warrant, law enforcement accessed privileged communications between attorneys Frank Prieto and Sabrina Puglisi and their clients Courtney Clenney, Kim, and Deborah Clenney, which occurred after Courtney's incarceration. These communications took place in a group text the chat was titled quote unquote Team Courtney, involving the attorneys, their paralegal investigator, and the parents and Courtney Clenney prior to her arrest. I did read that document, so it is in the playlist if you want to know about the ADA stepping down and the role that it plays in this. At no point did anyone from the state attorney's office contact counsel to ascertain whether Kim or Deborah Clenney were represented by counsel, despite knowing the counsel represented their daughter, nor did they reach out to Mr. and Mrs. Clenney to inquire about the representation in order to filter through their names from any subsequent search. ASA Quinnen, who is the man who has stepped down in that office, attempted to justify his search of those overly broad materials by stating that he asked counsel for that contact information that should be subject to a filter. However, he failed to disclose that he intended to serve a warrant on iCloud accounts. He deceptively indicated the alleged filter was sought for and would only be applied to Ms. Clenney's iPhone seized at the time of her initial detention. Neither law enforcement nor the state attorney's office established a filter to prevent the review of attorney-client or product privilege communications as applied to any of the iCloud accounts or the phone seized at her subsequent arrest. Consequently, privileged communications were reviewed by both law enforcement and the state attorney's office. ASA Quinnen conducted a search of the iCloud accounts and discovered the Team Courtney communications. The content of the Team Courtney chat involved discussions regarding all matters related to Courtney Clenney's case, including communication regarding case investigation, witness testimony, defense witnesses, expert witnesses, financial obligations, defense theories, counsel's thoughts and impressions, and opinions on the case. These were communications that the parties believed to be private and privileged. During the unlawful review of the privileged communications by the state attorney's office and law enforcement, they uncovered text about a laptop in the possession of Clenney's family and the defense's investigation into its potential evidentiary value. On February 1st, 2024, the state attorney's office, relying solely on the privileged communications and without any additional evidence, filed an information in F-245 B&C charging Courtney Kim and Deborah Clenney with unauthorized access to the laptop. When drafting the arrest warrant for the defendants Kim and Deborah Clenney, ASA Quinnen approved the inclusions of attorneys Frank Prieto and Sabrina Puglisi as uncharged individuals who allegedly committed the crime alongside the charged individuals. It was only later that the state attorney's office conceded that the undersigned counsels had not acted improperly. However, these accusations were made public in the warrant application. Information and multiple written pleadings by the state as well. In an unrelated written communication, Quinnen asserted that upon review of the text messages pertaining to the laptop, he immediately ceased review and went to obtain counsel from his superior co-counsel, state attorney's office, appellate counsel, and defense attorneys. On July 3rd of 2024, the court entered an order granting a motion to exclude and or suppress filed in case numbers F245, et cetera, et cetera. The order found that the communications reviewed by the ASA and law enforcement were privileged as attorney-client and or work product communications. So that's why the charges against her parents ended up being dropped. I just think most trial judges usually won't go against the previous trial judge's decisions, but you never know. You get a wild card judge. I mean, we never know, right? Yeah, it's crazy. Okay, let's continue. On August 20th, 2024, the defense filed a motion to disqualify the state attorney's office based upon the review of the Team Courtney chat. Subsequent to the filing of the motion, the defense was made aware of an additional and even more egregious breach of privilege by Assistant State Attorney Khalil Quinnen. On or about October 2024, after a public records request made by a third-party defense attorney, it was revealed that ASA Quinnen had also accessed another privileged communication sent from the attorney Puglisi to Courtney Clenney's parents. This communication included an attachment titled Courtney Checklist of Things to Do, Privileged Document. Upon opening the communication, the first page of the document clearly displays the fields from, sent to, subject, and attachments, with the from being the attorney for Courtney Clenney and the attachment specifically named as Courtney Checklist of Things to Do, Privileged Document. And I do want to just give an opinion about this really quick because I said this in the previous lives. I don't understand why, this ASA, he has been removed, but I think they had enough evidence and information on Courtney Clenney to lock her up for a long time. So all of this shadiness and stuff and improper or inappropriate behavior by the ASA, I felt like that could be tainting the case in some ways, clearly. The state insisted upon litigating these multiple breaches into the attorney-client and work product privilege, causing a massive delay in this matter. Ultimately, Judge Laura Cruz permitted the defense to take the deposition of ASA Quinnen to determine the extent of the breach into the defense camp in violation of the attorney-client attorney-work product privilege. ASA Quinnen, in the most unusual manner, filed a self-serving notice of withdrawal from Ms. Clenney's case, attaching his own interoffice memorandum on March 3rd of 2025. So that's when he removed himself. After the deposition of ASA Quinnen, the defense filed their amended motion to disqualify the Miami-Dade State Attorney's Office. So once he stepped down, Courtney Clenney's defense was like, well, you know what? Like, there was more people involved, clearly, and that office, what goes around comes around in that office, and people know of things. So her team was like, just remove everyone from that office. That was one of the motions we have read on here before. It is in the playlist. A hearing was held on the motion. Judge Cruz ultimately denied said motion on the grounds that the prosecutorial misconduct appeared to be limited to only the verified misconduct of ASA Quinnen. This order was entered on July 2nd, 2025, approximately 18 months after the defense first began to uncover misconduct on behalf of the state of Florida. Ms. Clenney has also recently filed another motion to dismiss based upon additional government misconduct and destruction of evidence, wherein City of Miami police officers instructed a witness to delete all video and photographs he had taken of the scene prior to the arrival of the police. That motion to dismiss on Youngblood and Brady grounds were filed on September 10th, 2025, and is also pending a state's response and hearing date. This motion for reconsideration follows Ms. Clenney's more than 3 years of pre-trial incarceration since August 10th of 2022. So she has been in jail for 3 years. Okay. So, argument. In Florida, the standard of substantial change in circumstances that may warrant a judge to reconsider a defendant's bond or the status of no bond after an Arthur hearing, pursuant to a Florida rule, focuses on demonstrating a change in circumstances or new evidence that was not available at the time of the initial bond decision. The state must present evidence that convincingly shows changed circumstances or new information to justify a modification of the bail order. There is no requirement that the defense make a showing of substantial change in circumstance. However, in the matter of sub judice, there has been significant and massive delays of almost 2 years caused by the government's misconduct. As referenced above, that constitutes a substantial change in circumstance. So they're saying, like, listen, because of the district attorney's office and the prosecutor's office, she has been held incarceration for 2 years because of those errors, which I'm kind of with the defense because I feel like, how would you feel if that was your aunt, sister, your whoever, um, and they keep messing up and she's incarcerated? So should they have let her out on bond, while they made their mistakes? I don't know, like what's right? I think we probably would all have differing opinions on that, but so, significant delay in the adjudication of Ms. Clenney's constitutional right to a speedy trial has been severely affected by the state's invasion of the defense camp, viewing of protected communications, and the filing of frivolous new charges. Further, whatever Florida statute allows the court to reconsider prior rulings on detention and states in the relevant part. Reconsideration. Either party may move for the order granting or denying pretrial detention to be reconsidered anytime before trial if the judge finds that information exists that was not known to the party moving for reconsideration at the time of the hearing, and that such information has a material bearing on determining whether there are conditions of release or bail that will reasonably assure the appearance of the defendant as required and the safety of any other person in the community from harm. Further, Judge Cruz's denial of bond, Ms. Clenney was based on evidence she received from the state during the Arthur hearing and at a subsequent motion to dissolve on October 18th, 2024, as indicated above. The state submitted to the court as part of their Arthur hearing packet certain recordings, and these recordings were surreptitious recording made by the decedent of Ms. Clenney in violation of Florida statute. So they're basically saying that video clips and evidence that was going to be used, they violated her rights by recording her and how it was presented to the state. These felonious recordings are a clear violation of law, and the legislator has made it abundantly clear they are per se inadmissible as evidence in any type of proceeding. And that's Florida Statute 934.06, which specifically states whenever any wire or oral communication has been intercepted, no part of the contents of such communication and no evidence derived therefrom may be received in evidence in any trial, hearing, or other proceeding in or before any court, grand jury, department officer, agency, regulatory body, legislative committee, or other authority of the state or a political subdivision thereof, if the disclosure of that information would be a violation in this chapter. These surreptitious, unlawful, misleading, and felonious interceptions should have never been considered by the court in making a bond determination as either the Arthur hearing or subsequent motion to dissolve. Florida Statute 934 was designed to effectively protect the privacy of oral and wire communications and to protect the integrity of court and administrative proceedings. In passing Florida Statute 934.06 into law, the legislator unequivocally expressed its desire to suppress evidence obtained in violation of that chapter, making it clear that these types of recordings are not admissible under the circumstances in this matter. I believe some of those videos too are the ones, if you've watched the body cam footage of this case, do you remember in the hotel when they're like arriving and it takes them forever to get to Christian? Jesus Christ, hours it seems like. Poor guy. There was like hotel people recording and stuff. And I think those are the evidence that they're talking about. But don't knock me. I'm not sure. It just gives the names of the files, so I don't know exactly what it is. Hopefully they tell us. Additionally, the weight of the evidence has shifted significantly with the discovery of additional evidence and expert witnesses to support the defense of justifiable homicide self-defense. At the time of the Arthur hearing, the defense argued that the motion for pretrial detention should be stricken because the court may order pretrial detention if it finds a substantial probability based on the defendant's past and present patterns of behavior, that the defendant has previously violated conditions of release and that no further conditions of release are reasonably likely to assure the defendant's appearance at subsequent proceedings, or the defendant poses a threat of harm to the community. The court may so conclude if it finds that the defendant is presently charged with a dangerous crime, that there is substantial probability that a defendant committed such crime, i.e., second-degree murder, that the factual circumstances of the crime indicate a disregard for the safety of the community, and that there are no conditions of release reasonably sufficient to protect the community from the risk of physical harm to persons. Those factors relevant to the case are A, the nature and circumstance of the offense charged, B, the weight of the evidence against Courtney Clenney, C, Courtney Clenney's family ties, length of residence in the community, employment history, financial resources, and mental condition. D, the defendant's past and present conduct, including any record of convictions, previous flight to avoid prosecution, or failure to appear at court proceedings. E, the nature and probability of danger which the defendant releases poses to the community. F, the source of funds used to post bail or procure an appearance bond, particularly whether the proffered funds, real property, or any proposed collateral or bond premium may be linked to or derived from the crime alleged to have been committed or from any other criminal or illicit activities. And G, whether the defendant is already on release pending resolution of another criminal proceeding or on probation, parole, or any other release pending completion of a sentence, the nature and probability of intimidation and danger to victims, whether there is a probable cause to believe the defendant committed a new crime while on pretrial release, and any other facts that the court considers relevant. The state selectively presented parts of the discovery to the court and the media, creating an incompetent and inaccurate picture. Okay, this is crazy. At the time of the Arthur hearing, the defense had not yet fully evaluated the extensive discovery materials. Although there were no witnesses to the event in the apartment on April 3rd of 2022, evidence indicates that Miss Clenney and Obumseli, Christian, her boyfriend, had a tumultuous relationship. I really want to do a live later on the body cam again. I think I really want to get into it again because I have the text messages as well. So if she previously violated conditions of release, even just one violation, there's no chance for her to get bond. Yeah, but I don't think she has violated any conditions, which is why they want her to get bond. If anything, they're saying that, the ASA's office is the one who has violated conditions. During the Arthur hearing, the evidence was biased, portraying Miss Clenney as the instigator with violent tendencies. And they're talking about the elevator video and superstitious recordings that were improperly considered by the court. So, that elevator where she starts beating him, and then the other clip when their friend is recording them. I might play these. They're fighting and the friend is like recording them. That's what they're talking about here. Since then, as argued in the motion to dissolve pretrial detention order in October of last year, the defense has discovered a key witness corroborating Obumseli's physical abuse of Miss Clenney. So that's wild. Arthur Cupp, a witness known to the state during the Arthur hearing, told police via body-worn camera footage on the incident date that he previously saw Obumseli pummeling Miss Clenney from his apartment across the street. So, yeah, there's a witness, I guess, that saw Obumseli also putting hands on Courtney at some point. Compelled by what he observed, Mr. Cupp, a neighbor with a direct view into Miss Clenney's apartment, approached the police on the incident date to report his observations. Statement from other neighbors document Obumseli acting aggressively towards Miss Clenney in the days leading up to April 3rd, 2022. Interviews conducted by the City of Miami Police Department after the events demonstrate that Miss Clenney was clearly a victim of domestic violence. These statements, along with reports from security personnel who contacted law enforcement less than 48 hours before Obumseli's death after witnessing him aggressively charging at Miss Clenney in the lobby, supported this assertion. During that incident, Miss Clenney implored the police for a restraining order against Obumseli, and her pleas were documented on the body-worn cameras of the responding officers. These statements have since, in the months following denial of Ms. Clinton's motion to dissolve pretrial detention last year, have been corroborated in the collateral civil proceeding through sworn testimony by the state at the One Paraíso building where the tragic incident occurred. So there they're referring to, that fight that they had just like a few weeks before. They're saying that, that was like an event. Thank you, Monica, for subscribing. Courtney's such a victim, is as much as victim of a DV as Sarah Boone. Okay. Yeah, Sarah Booney. We're going to cover her too. Mr. Cupp, a defense witness unknown to the defense at the time of the Arthur hearing. So the defense didn't even know this was going to be a witness. Was unable to provide testimony for the court's consideration. However, his proffered testimony and statements were considered by the court at last year's motion to dissolve the pretrial detention order. As pointed out in that hearing, additional evidence supporting Ms. Clenney's claim of self-evidence includes testimony from the defense experts Bobby Branton and Dr. Maricini, who will assert that the knife in question could be thrown and penetrate the decedent to a depth of nearly 3 inches with a slight downward angle. Ms. Clenney consistently stated to initial responders and later at the police station that she threw the knife in self-defense. I really don't want to knock people who have experienced DV, but like Courtney Clenney, there is evidence that she stabbed Obumseli before. So this wasn't the first time she tried to stab him. And we can go through that in a different live. But there's proof that, she had stabbed him before. So is that self-defense? The state's medical examiner testified, and why are you stabbing your boyfriend? Like, just saying, like, is that what people do in relationships? Shit, no wonder I'm single, because I don't want to stab anybody. The state's medical examiner testified that in his opinion, it was not possible for the knife to have been thrown, as Miss Courtney Clenney claimed, though he admitted he was not a knife throwing expert. The defense's expert's testimony validate Miss Clenney's statement and corroborate that her actions were justified. Finally, the world's leading expert on battered spouse syndrome, Dr. Lenore Walker, is expected to testify at trial that Miss Clenney was suffering from battered spouse syndrome. That's impressive. The world's leading expert is going to be testifying on her behalf. And do I believe two things could be true at once? Yes, that they were both violent with each other. I would want to see more proof of Christian putting hands on her, because like all the videos we have and all the text messages don't ever show that. So I don't know. It's hard for me to believe that. Dr. Walker will testify as to Courtney's state of mind at the time she was forced to take action in the defense of her life. Additionally, newly discovered evidence in the matter reinforces Ms. Clenney's argument that the state of Florida has overcharged this matter from the inception of the case. This new evidence changes the calculus of the state versus Arthur analysis, as this matter should have never been charged as a murder, but more appropriately as manslaughter. At the Arthur hearing, the state pushed forth a false narrative concerning Ms. Clenney's actions after the injury to Mr. Obumseli. Clenney argued at the Arthur hearing that at best, this matter was more appropriately charged as a manslaughter, which is a bondable offense. How do you guys feel about that? Should this be manslaughter? Before she was arrested, almost killed another boyfriend. That's actually true, Bo Barron. That is actually true. I have covered that here before. Self-defense for imminent circumstances. The keyword is imminent. If she used any force that serves to stop force from him, it's self-defense and the force is proportionate. Well, the state of Florida argued that Ms. Clenney, rather than calling 911, allowed Mr. Obumseli to bleed out for 13 to 14 minutes while on the phone with her mother. So think about Christian bleeding for 13 to 14 minutes while she was on the phone with her mother, probably plotting what to do and how to handle the situation. And then on top of that, it took EMS, I think like a total of 7 minutes to get to the freaking floor. So for like 20 minutes, he was bleeding out and had no assistance. Where's the justice for Christian Obumseli here? And I don't think his family has gone after the police department. I know that they thought about it, um, and that could be pending. They might wanna sue Miami State Police Office, which they should. Clenney's, if they watch this, which I'm sure they probably don't, or who knows, maybe they do. Definitely sue them after this is all figured out because I don't know, maybe I'm just being a bitch. Miss Obum This argument was part of the state's theory of second-degree murder versus manslaughter. To prove the crime of second-degree murder, the state must prove the following three elements beyond a reasonable doubt. Christian Obumseli is dead. Okay. The death was caused by the criminal act of Courtney Clenney, and that there was an unlawful killing of Obumseli by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. It goes back to what First Liberties just said. And yes, I feel like that's true. She didn't know how to help him. She cut him twice before. Um, let's see. Prosecutors at the Arthur hearing pushed the narrative that Miss Clenney allowed the decedent to bleed out during the calls with her mother, arguing that her overall conduct demonstrated a depraved mind without regard for human life. I actually agree with this statement because why are you on the phone with your mom? It brings me to the Idaho case. I know we're not here to victim blaming, and I'm not. But like, what took you so long? 8 hours, by the way, to call the police. And then you call your family first. And then this is the same situation. Why are you calling your mom first and not the police? Does that prove guilty conscience of some sort? You know what I mean? I don't know. If you stab someone to death, who are you calling first? Or your mom or the police? I guess I'm curious what everyone thinks. Absent this Absent this element, the state is left with a manslaughter charge, which is more appropriate charge in this matter. The state continues to fail to set forth sufficient evidence establishing evident proof proof evident, presumption great for second-degree murder. In Miss Clenney's interview, Miss Clenney's mother's statement to police. Miss Clenney and her mother both stated that 911 was almost immediately called after the injury to Mr. Obumseli. Miss Clenney's defense team has recently become aware through collateral proceedings that Dr. Millard, a current medical examiner in Hillsborough County, Florida, has opined that Miss Clenney called 911 immediately after the injury. This negates and obliterates the state's theory that Miss Clenney allowed Mr. Obumseli to bleed out. So I guess in that exhibit, which I don't know if I've read that one, I guess someone's saying that how would they know? I don't know. They're a medical examiner, I guess. That she did call. How would they know? Maybe by the amount of blood he lost? I don't know. This new evidence clearly establishes that at best, this case is a manslaughter case. If it was not for the clear case of self-defense as further buttressed by the world's leading expert on battered spouse syndrome, Dr. Lenore Walker, quote unquote, it's extreme recklessness or an impulsive overreaction to an attack or injury is itself insufficient to support a second-degree murder conviction. That's who's going to testify on her behalf. Further, an impulsive overreaction to an attack or injury is insufficient to prove ill will, hatred, or spite. Bond in this matter is appropriate and has been granted in other cases throughout the state. See order granting bond for female defendants accused of second-degree murder involving a spouse or significant other. So remember at the beginning when I brought up the black swan? Well, because they're going to bring it up. So time has passed, cases have continued as Courtney Clenney sits incarcerated, eating honey buns and paying $3 for a 15-minute conversation to her parents. Poor girl. Now she's saying that they're basically saying that, she should be out of what? I lost my train of thought, sorry. Um, that she should be let out while I was talking about Swan Dancer, thank you. While she was incarcerated, Ashley Benefield, the Swan Dancer. I don't remember the name they gave her. The case, the Black Swan case, I think. Was it the Black Swan case? Um, anyways, her case recently just happened, so they're gonna bring that case up here. Additional misleading information presented by the state of Florida at multiple hearings. In reviewing the state's pretrial detention memorandum, the state inaccurately claimed that Ms. Clenney immediately fled the jurisdiction. State's pretrial detention memorandum, page 9. In reality, Ms. Clenney, through her counsel, maintained consistent contact with law enforcement. She did not flee, but instead returned to her home in Texas, where she and her family resided before her relocation to Miami to seek treatment for PTSD and substance abuse issues. That's great. I'm so in support of mental health issues and getting help, and I have been there. We can talk about it on the second channel. And that's great. It's really great and all. I do encourage it. But why the hell are you getting help 5 years after you first put hands on your first boyfriend and had issues with substance abuse? And especially after having money from OnlyFans. Like, she had the means to get help, but she's just doing it now after she's looking at, life in jail or whatever. To bolster their request for pretrial detention, the state further argued that Ms. Clenney fled the Texas jurisdiction to California. This assertion is also false and misleading. Ms. Clenney has a pending misdemeanor DUI in Texas and traveled out of state because there were no court-imposed restrictions on her travel. That case has since been resolved. So there's that. Florida statute requires that the defendant pose a threat of harm to the community. The evidence in this case does not suggest Courtney is a threat to the community. She has no prior criminal history that involves violence or threat to someone other than Mr. Obumseli. The state also argued that the transfer of funds from Courtney to her father on April 3rd of 2022, while the investigation was pending, was quote unquote an apparent effort to relocate and conceal assets. In reality, Kim Clenney, her dad, took over managing his daughter Courtney's financial obligations after April 3rd of 2022 because she was suffering from PTSD and excessive alcohol consumption. Okay, well, Kim Clenney, Daddy-O, why didn't you help her before? Why did you not have responsibility of her money before if you knew she was acting a fool, being a drunk, which we have all been there. It really sucks. But my point here is not that. My point is they had the means and opportunity to do all of this previously. Then, now they're trying to approach it like, oh, he's protecting her money because she can't control it. Okay, but you let her control her money. Her what, $3.5 million she got off OnlyFans making sex tapes, which I have seen and I don't recommend you watch. I needed evidence. It was for research. But nonetheless, with the man she stabbed. So there's that. Anyways, in reality, Kim Clenney took over managing I already said that. She was suffering from PTSD. While funds were transferred to Mr. Clenney, it was not to hide assets, they say. All expenses, including the largest expense of attorney's fees for Courtney's defense, are fully accounted for by Mr. Clenney, which I do believe. It's been 3 years. She has good lawyers. They're probably getting expensive. The funds to pay a bond in this matter would come from her parents, as Courtney Clenney is essentially broke. Her home has now been foreclosed upon. Miss Clenney may also face a deficiency judgment once the bank sells the home. So they're saying she has no money. She's broke. You should let her out on bond while we fight this. And she's not going to fly or flee to anywhere because she doesn't have the money. Her home is now foreclosed upon. I think it would be important in this instance to have OnlyFans enter the chat and give documentation on how much money she is still making off of those old videos or how much she's not. Maybe they're all taken down. I don't know. I don't know about that. That was a long time ago for research, but I don't know if it actually is still up. Ms. Clenney has zero assets and zero money. Further, the prolonged litigation has fleeced her family of their own savings. In sum, there are no assets that Ms. Clenney can access that would establish a risk of flight. Finally, as indicated above, the government has acted improperly in numerous respects. One, presenting an overly broad warrant application. Two, failing to implement proper filter protocols to ensure attorney-client privilege communications were not reviewed. And three, reviewing attorney-client communications in violation of the law. And four, law enforcement, with the approval, assistance, and at the direction of the state attorney's office, filed an affidavit supporting a search warrant for Kim and Deborah Clenney's iCloud accounts. 5, law enforcement instructed a witness to delete videos and photographs. With respect to 3 and 4 above, the warrant saw everything on the iCloud, photographs, texts, emails, notes of Deborah Clenney due to messages exchanged with Courtney immediately after the incident on April 3rd, and known photographs taken by her mother. It also saw Kim Clenney's iCloud data due to the commingling of funds between him and his daughter after Obumseli's death. The warrant covered a period of 17 months before and 10 months after Obumseli's death. The privileged communications read by the state attorney's office were made after Ms. Clenney was in custody, during which she had no phone communications with her parents. There was no valid reason to request or review those communications, as they were irrelevant to the investigation and inconsistent with the warrant's application reasoning. So maybe the warrant didn't state the facts that it needed to state. You know, like, we want to know how shady you and your dad were texting prior to this. Attorney-client privileged communications are sacred. Every state attorney's office has protocols to ensure such communications are not breached. In this case, at the very least, ASA Khalil Quinnan made no attempt to determine if Kim and Deborah Clenney were represented by counsel. There is no obligation for their attorneys to inform their state of the representation. Mr. and Ms. Clenney are listed as state witnesses, so the state attorney's office could have easily contacted them to ask if they had counsel or contacted undersigned counsel, knowing they were the parents of his client and would likely know if they were represented. The more likely answer is that the state attorney's office did not want to, quote unquote, tip off the Clenneys that they had sought a warrant for their communications, because they simply view everything through prosecutorial blinders, as reasoned by Judge Cruz in her order suppressing evidence. The state attorney's office admitted to having reviewed attorney-client communications and desperately tried to make frivolous arguments justifying their review. Despite having no evidence to support their theories, the state continued to litigate this matter through extensive motion practice, delaying this matter even longer. The court ruled that an attorney-client relationship existed. The communications were privileged, and no exception justified the state's review of such communications. Initially, the state argued that no attorney-client privilege existed due to a conflict of interest for undersigned counsel representing them. The state misunderstands the proper procedure for a potential conflict. It is not to unilaterally decide there is conflict, thus negating privilege. The state attorney should have motioned the court, advised of the potential conflict, and sought the court's review to determine 1, if a conflict existed, and 2, if the clients could give a valid waiver of any conflict. Instead, the state attorney's office made the decision unilaterally. Additionally, the warrant application incorrectly stated that the parents could not be represented because they were listed as state witnesses. No case law supports the notion that a state witness is precluded from having representation. Although the detective wrote the warrant application, he testified that ASA Quinnan assisted him in the legal portion of the application. Remember, ASA Quinnan is the one who had to step down. While ASA Quinnan claims to have only read a small portion of the communication related to the laptop subject to the now dismissed charge, it is questionable whether this is reasonable. If ASA Quinnan believed there was no attorney-client privilege, which is what's stated in the warrant he prepared, what prevented him from reviewing the entirety of the communication that discussed defense theories, witnesses, experts, financials, etc.? As a direct result of these errors and the continued frivolous litigation On the part of the state, Ms. Clenney remains in custody with her case having remained as a standstill for almost 2 years now. Because on the new evidence above that negates any theory of second-degree murder, the state of Florida cannot meet their burden of proof evident. Presumption, great. Dr. Mylad Webb's expert opinions shed light on the state's inability to prove that Ms. Clenney's actions on April 3rd of 2022 constituted an unlawful killing of Obumseli by an act imminently dangerous to another and it demonstrating a depraved mind without regard for human life. In addition to the new evidence, the prior court's decisions on bond were, in part, based on the improper review of surreptitious recordings that should have never been considered as they are wholly inadmissible. Were it not for Miss Clenney acting in self-defense, the evidence in the matter more appropriately supports a charge of manslaughter, which is a bondable offense. So now that you know everything that's happened, do you agree that she should be charged with manslaughter? And do you believe she should be out on bond? Let me know what you think. The conclusion: the evidence now more fully evaluated reflects a long history of mental, emotional, and physical abuse inflicted by Miss Clenney's abuser. I don't like that. The calculus has shifted in favor of granting a bond in this matter when considering expert testimony and or reports and anticipated testimony in this matter. Ms. Clenney has been clean and sober for more than 3 years since she began rehabilitation in Hawaii prior to her arrest. The court can impose conditions to ensure Courtney's appearance in court and the safety of the community. The defense recommends a monetary bond with special conditions, including home confinement. Ms. Clenney can participate in electronic GPS monitoring system from her family home in Texas, with the program providing regular reports to the court in the state. She should also attend an outpatient treatment program for PTSD and alcohol and drug abuse. The defense requests that the court release her to the custody of undersigned counsel to travel with her to Texas and ensure the monitoring system is implemented. Signed December 3rd, 2025. Now we'll get to see some of the exhibits, but before we get to the exhibits, okay, now let's compare. Jamie Komorowski, she killed a bride drunk driving. Do I enable drunk driving? No. Do I defend it? But you are drunk driving. I've been there before, but nonetheless, I feel like if Jamie Komorowski was let out on bond on house arrest, should Courtney also, like, considering if you truly believe she is a victim and she was having mental health issues, like, should she be out on bond right now? Like, my head is like, no, 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 no. But then I think maybe, like, after all of these mistakes, all this money, all this time she's been incarcerated with ASA being shady and evidence not being presented. I mean, like, how would you feel if your case was handled like that? You know, like, should she get bond until they figure it out for the rest of the time? So they're looking to have a trial like summer of 2026. Good for her getting clean, but she's still an unaliver. Yeah, exactly. It's like a little too late. No, is she out? She's not. Jamie Komorowski was let out before she was sentenced. That's I was just saying, making like a comparison. Like, should Courtney Clenney be out as well while she waits? So I told you I'm not gonna read a lot of the exhibits that I have already read before. Um and I have already read this one, I believe. This was the order denying release. So we're going to skip through that. I just want to make sure I don't skip through any good exhibits. And if so, then yeah, I'll read it. This was back in, I think, 2022, this motion for release. Yeah, December 8th of 2022. I've been following this case. I'm obsessed with it. Exhibit B was the order denying defendant's motion. Okay, so they deny the bond, right. And then I know Exhibit C to suppress and include this. This is when the computer, remember they tried to say that her parents and her were trying to hide stuff in the computer, in Christian's computer and her stuff in relation to Christian. So that's where those charges from the laptop were initially born against her parents, but those were dropped. And that was in June of 28th, 2024. Exhibit D is okay, same thing, order denying. Exhibit E is expert forensic review and opinion. This I have not read over. So let's read over this part. So it says on April 3rd, descendant Mr. Christian Obumseli, a 27-year-old black male, was involved in domestic altercation in a residence located in Miami, Florida. It was ultimately determined that the descendant suffered a sharp force injury to the chest. Miami police and fire rescue responded to the scene and transported the decedent to Miami Jackson Memorial Hospital Ryder Trauma Center, and he was pronounced dead that same day. He has no significant medical history. Postmortem examination was performed by Dr. Hutchings on April 4th, 2022. External examination revealed a well-developed black male of 200 pounds. A stab wound is identified on the upper right chest below the level of the clavicle and medial to the right shoulder. Within the wound, injury is noted to the right subclavian artery. And that's why Christian died too. The subclavian artery is a major artery in our bodies. And so the fact that she was on the telephone crying to her mother for 14 minutes, and then it took poor EMS 7 minutes to get out there. Well, no shit, he bled out like 20 minutes. A subclavian artery can injury, you can be dead within minutes. No significant trauma is noted. No significant medical conditions are identified. Slight increase in cardiac size is noted. However, this is appropriately classified as a normal variant for an athletic build. The cause of death is certified as a stab wound of the right subclavian artery. Because not only does it go to your blood to your arm and your heart, it also designates blood to your brain. So this is a review of the photographs from the post-mortem examination. I've never actually read this one. There are 24 images. It says these images are consistent with description in the autopsy report. Internal examination of the wound appears to reveal a small defect in the tributary of the right subclavian vein. The exact size of the defect is difficult to determine as there is no scale included in the photograph. This defect is not described in the autopsy report. However, given the close proximity of the right subclavian artery and vein, it may represent a small traumatic perforation in a subclavian tributary or postmortem artifact from soft tissue dissection. The autopsy report states there was no injury to the subclavian vein. It appears that Obumseli rods are used to trace the course of the artery and the vein to show that the artery is perforated. The perforated right subclavian artery is dissected away from the body and documented. The exact size of the defect is difficult to determine as there is no scale in the image. However, it appears significant when compared with the overall circumference of the artery. The injury to the decedent was localized to the right subclavian artery. There are three main arteries that branch off the thoracic aorta. The first of those branches is the brachiophiliac artery, which bifurcates and gives rise to the right carotid artery and right subclavian artery. The right subclavian artery, a large caliber vessel, then supplies the right upper extremity, vertebral artery, internal mammary artery, thyrocervical trunk, and coast cervical trunk, and dorsal scapular artery. Damage to the subclavian artery is a rare occurrence in relation to other extremity vascular injuries and accounts for approximately 5% of all arterial injuries. However, these traumas carry a high rate of mortality due to rapid exsanguination, difficult achieving surgical control, and low likelihood of tamponade. That's what I was just saying to you guys. Like, there was no way he would survive if it took them 20 minutes to get any type of medical help. Surgical repair of the subclavian artery is considered difficult primarily due to its deep anatomical location. The subclavian artery is protected by the clavicle and thoracic cage, which restricts direct access and creates a narrow operative field. This makes vascular control and repair technically challenging, especially in case of trauma. Exposure often requires extensive incisions, including incision of the clavicle, particularly for proximal injuries. These approaches risk injury due to adjacent nerves, thoracic duct, and other major vessels. In addition, intraoperative bleeding can be difficult to control due to the high pressure systemic circulation and limited space for clamps and suturing. Penetrating injuries to the subclavian artery are associated with pre-hospital mortality rates of up to 75%, primarily due to exsanguination. So basically, why they're showing this exhibit here is because they're saying that even if it took EMS that long and Courtney was on the phone that long, they're going to use this to say she did not, what was the quote? It's like malice or hatred or whatever. Like they're saying that she is ultimately not responsible because if she did this because of self-defense, the fact that this artery was really hard to get to and he was not going to be able to be saved regardless, that's why they're introducing this exhibit again. That's what this is. The mechanism which results in death following such a devastating arterial injury is exsanguination. Loss of blood is hemorrhage. Loss of blood resulting in death is exsanguination. Exsanguination, I don't know if I'm saying that right, involves a cascade of physiological events driven by rapid and severe blood loss, ultimately leading to unconsciousness and death due to inadequate oxygen delivery to vital organs. Initially, compensatory mechanisms such as increased heart rate, vasoconstriction attempt to preserve perfusion to the brain and heart despite failing blood volume and pressures. As blood loss progresses, these mechanisms fail, resulting in systemic hypotension, decreased cardiac output, and impaired tissue perfusion. At the tissue and organ level, cerebral perfusion is critically compromised, leading to cerebral ischemia and hypoxia. This manifests clinically as confusion, lethargy, and ultimately unconsciousness as neurons of the brain and the brainstem die. Simultaneously, hypoperfusion of the myocardium can precipitate fatal arrhythmias of the heart. Systemically, severe hemorrhage triggers coagulopathy, hypothermia, and acidosis, which further impair hemostasis and cellular function. There's some charts basically proving, the blood, blah, blah. Okay, we get it. Estimation of blood loss and post-injury survival time. This is interesting. To estimate blood loss, okay, so it says 6.8 liters blood volume. The decedent's, so they actually used his, but can be calculated using the standard 75, okay, cardiac output. Measure of the heart's ventricular function represents the volume of blood circulated. I don't know what that means. During the exercise, okay. Using the estimated blood volume of the decedent and the calculated rate of blood loss through the right subclavian artery, the time to onset of hypovolemic shock and approximate post-injury survival time can be projected mathematically. Okay, I'm not trying to go back to school right now. Notably, okay, let's see. Notably, the cardiovascular system is not static during significant hemorrhage. Based on the calculated estimates of blood volume and the projected rate of hemorrhage through the right subclavian artery, it is reasonable to conclude that the onset of hypovolemic shock had occurred as early as to 1 to 4 minutes following the initial injury. I told you guys it was minutes. 1 to 4 minutes. Thank you, Malice with forethought. That's what I was thinking. Yeah, so I guess he was already, in shock at 1 to 4 minutes. Poor guy, dude. Took him 20 minutes to get him out of there and then the travel to the hospital. As hemorrhage continued, the decedent would have experienced progressive cardiovascular decompensation with terminal blood loss, defined as a volume loss incompatible with survival, reached approximately 8 minutes post-injury. Given the high flow capacity of the subclavian artery and the absence of any effective tamponade or intervention, blood loss would have been rapid and severe. With a high degree of medical certainty, the decedent reached a non-survivable level of blood loss within 10 minutes of the injury. So yeah, the defense is using this to say, hey, even if she wanted to save him, she couldn't. But she couldn't save him because he was bleeding out and she's not a doctor and she was going through shock from being battered and from being a victim of domestic violence. I don't know how I feel about all of that. Let's review this timeline. We're almost done with this document. Based on the available information, it is my opinion that the stabbing incident occurred between 1651 and 1656 hours. During the verbal altercation, Courtney initiated 2 calls to her mother beginning at 1643 hours. 3 minutes later, at 1646 hours, the front desk of the building contacted 911. There is no evidence that any injury had occurred at the time of the initial 911 call. Yeah, I don't believe EMS found out until they were on their way up in the elevator or waiting for the elevator to open and come down. Building security management arrived at the unit at approximately 16:50 hours and knocked repeatedly on the door. No one answered. However, shouting between the couple could be heard from the inside. At this point, there remained no evidence of bodily injury. Clenney and Deborah, her mother, later stated independently that she was on the phone at the time of the physical violence between Christian and Courtney. The call with Deborah was terminated by Clenney at 16:56 hours, and a call to 911 was initiated at 16:57. The most reasonable inference is that the fatal incident occurred sometime between 16:51 and 16:57 hours, most likely just prior to the 16:57 call to 911. At approximately 16:58 hours, building security management returned to the unit where the door was open and Clenney was visibly covered in blood. Security management personnel observed that Obumseli appeared unresponsive on the ground and there was blood everywhere. It is my opinion that Obumseli has lost 30 to 40% blood volume at this point. Wow. I think everyone should be able to have a speedy trial and shouldn't have to sit in jail for 3 years while they wait. She should be out on bond and bracelet, in my opinion. Yeah. I don't want to. It's hard for me to give like an opinion because of my prior experiences, but yes, I kind of agree with that. But do I believe she was a victim? Not necessarily. 2 whole different things. At 1700 hours, EMS was dispatched to the location. At approximately 1704 hours, building security management escorted MPD officers to Unit 2201, and Clenney was placed in handcuffs at approximately 1706 hours. Officers Angel Carbello and Fernando Fleites were the first to enter the apartment. They arrived at the building first, met with security management in the lobby, and were escorted to the unit where they found Courtney and Christian on the floor covered in blood. The officer entered immediately behind Carbello, who physically engaged first, moving Clenney aside, applying handcuffs for safety, and attempting to control bleeding until fire rescue arrived. I think a little too late. The officers documented that Christian was initially unresponsive, attempted to sit up or move, and immediately collapsed. That event likely represented Christian's terminal collapse. No subsequent signs of responsiveness were recorded. It is my opinion that Obumseli has lost more than 40% of blood volume at that point. If Christian was stabbed at approximately 16:56 hours, just before Courtney called 911, he would have entered severe hypovolemic shock between approximately 16:58 and 1700 hours and would have lost over 40% of total blood volume by around 1704 hours. These estimates are consistent with witness reports, deposition testimony, and available video footage. EMS response and pronouncement of death. The time to establish a safe scene is critical as EMS personnel do not enter a scene until law enforcement has confirmed it is safe. Standard EMS practice prioritize responder safety, requiring crews to stage away from potentially hazardous environments until the police secure the area. This protocol is consistent across EMS systems nationwide. Even if in an alternate scenario in which EMS were dispatched earlier and arrived before MPD, they still could not have reached or accessed Obumseli until approximately 1706 hours. There we go. This is why the defense is presenting this, because they're saying that Obumseli was already basically dead. Safe stage, and she couldn't do anything about it. Nobody could. Well, if Courtney didn't stab him, he wouldn't be dead, bleeding out. Okay, but regardless, let's continue. Safe staging would have occurred at the lobby level due to the confined space on the 22nd floor. In this model, MPD would declare the scene safe at 1707 hours. EMS would load the elevator and reach the unit by approximately 1709, and the first assessment would be completed at 1710 hours. Under optimal conditions, this alternate sequence might shorten the response time by only 1 to 2 minutes. The EMS report documents in fair detail the initial assessment and treatment provided to the decedent. Most importantly, at the first documented assessment, the decedent was found to be in terminal arrhythmia known as pulseless electricity activity. PEA, pulseless electric activity, arrest is a form of cardiac arrest characterized by organized electrical activity on the electrocardiogram that should generate a pulse but does not. PEA is without a palpable pulse or affect cardiac output. In essence, the heart's electrical system remains active, but the mechanical pumping function is absent or inadequate to sustain life. PEA arrest represents cardiac arrest and a clinical state of death requiring immediate resuscitation with high quality chest compressions. However, chest compressions were not initiated until 13 minutes later when the decedent lost electrical activity. At no point did the decedent's perfusion state improve. He remained in a persistent anoxic condition through the EMS and hospital response. Persistent arrest, despite resuscitative efforts, met the established criteria for legal pronouncement of death. From EMS first arrival until the official pronouncement at 1755 hours, there was no measurable change in any biological function, indicating that Obumseli was ever alive during that period. Wow. The duration of resuscitative attempts does not constitute life. The pronouncement of a death by a medical professional is largely a matter of clinical judgment. Whether resuscitative efforts continue for 10 minutes, 45 minutes, or not at all lies within the provider's discretion. The decision to declare death a few minutes earlier or later is arbitrary and does not alter the underlying physiological reality. When Christian was legally pronounced dead at 1755 hours, that reflected the point at which resuscitative efforts ceased, not a moment of physiological transition. Death could have been pronounced upon arrival at the hospital at 1726 hours at the time of first assessment, where the decedent was GCS3 with non-reactive pupils indicating critical neurological dysfunction, herniation, and or brain death. So basically, Christian just died there on the floor. And although basically his body was already like, the pronouncement of death is inherently arbitrary because it is based on socially legal and medically constructed criteria that do not always align with biological reality. The termination of death, whether by cardiopulmonary or neurological criteria, has evolved in response to advances in medical technology, societal needs, and legal frameworks rather than a single universally accepted biological endpoint. In this case, the decedent sustained a devastating arterial injury from a stab wound to the chest. At no point was survival likely following such an injury. Based on the available information, it is apparent that Christian's death occurred rapidly, and the efforts of first responders could not overcome the catastrophic nature of the wound. There is no evidence to suggest that a shorter EMS response was warranted at the time of the initial 911 call, was feasible given scene safety considerations, or could have altered the outcome. Summary of opinions. Okay, so it says, I have reviewed the postmortem report. Okay, there was no contributory causes of death. There's no identified medical conditions. There was one fatal injury to the decedent's body described as a stab wound to the right upper chest. Okay, we already read that. This is a catastrophic injury. Stabbing occurs between 1651 and 1656. Basically everything we just read. And there's references. Let me make sure there's nothing left we need to catch on this. Oh, the pictures. Okay. Geez, I feel like I'm back in class right now. Was it the right subclavian or left? I can't remember now. Interesting. The right subclavian artery is a major vessel that carries a large volume of blood from the heart to the right arm. It begins in the upper chest, just behind the right collarbone, the clavicle, and curves outward towards the shoulder. Along the way, it also sends branches that supply blood to the neck, upper chest, and right side of the brain. An injury to this artery can cause rapid and significant blood loss. Yeah, we know that. I said that at the beginning. Interesting. Okay, and then this is just documents received. Okay, evidence. Depositions, body cam. Okay. Exhibit F is bond reduction or supervised release. Murder in the second degree with firearm. I think this is the older one, yeah. As a bond in 250,000. Yeah, that was from 2019. Wait, 2019. Oh, this is the other case they're referring to. You know, the case of Marcia Thompson? That's who they're saying that she got bond. Did she get bond? I don't remember that case. Oh, yeah, so they basically brought that case up. That's what this was. Exhibit F. The court in 20 that's why I was like, "Wait, 19 to Senate Arthur." So Marsh is it Marcia? The defendant is charged with indictment with first-degree murder with firearm. I'll have to look back into that case. Anyways, that was the document. We did it. We got through it. It was the right side, yeah. Hey, Mary Beth, it must have been the right side, that's all right. Yeah, I figured it out after the fact. Um, Interesting. So, there's that. That's the recently filed motion for Courtney Clenney case. I'm keeping my eyes on the docket because I wanna know as soon as they respond, is she getting out on bond? Is there gonna be a hearing? What is gonna happen? What is going to happen with this case? We've been waiting for trial forever. I actually wanted to cover Courtney Clenney because that's who was supposed to start the same day as Brian Walsh trial. But again, it got changed. So when this does go to trial, absolutely, we will be covering it. But that could probably take some time and she might be let out on bond. Nonetheless, that's it for this document. Thank you so much for being here. Please, 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 I will link the document in the description, but that won't be until later. Whatever they do, they need to hurry up. Exactly. I agree. This is always I'm gonna make another live for this weekend so we can review some of the body cam because it's been a while. I know I do it like every year, but um there's some stuff I think I want to re-review. But anyways, please hit the like button, hype this live up. Please, 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 please. Like I said, if you did not get the link to the second channel, it is in the chat. Please subscribe to the second channel. We will be live on there today, later tonight for fun. But I do have a Kenzie Shirella live coming up later today. So definitely turn on your notifications. Thank you so much for being here. I will definitely keep you guys updated on Courtney Clenney case, and I will see you on the next live.